The right to a dignified death. It's something that's deeply personal, but also incredibly complex legally, especially here in India. So today, we're going to dive into what passive euthanasia actually means, how the whole thing works, and some of the really tough challenges that people are facing.
To really get a handle on this, it helps to look at a real-life situation. Let's talk about Harish Rana. He was just 32 years old and had been in a vegetative state for years. The Supreme Court recently made a landmark decision. They allowed his family to withdraw life support. And just like that, this heartbreaking case pushed the whole debate about a dignified end of life right into the spotlight. It's cases like his that show us why this conversation is so important right now.
All right, so here's our game plan. We'll start with what we're even talking about, a matter of choice. Then we'll walk through India's official procedure. After that, we'll get real about the practical hurdles. And to wrap it up, we'll look at the power of a will, which is a really important tool for all of us.
Okay, so first up, a matter of choice. Let's get our definition straight, because when we talk about this, the words we use really matter. There are key differences here. Okay, so this is absolutely crucial to understand. On one hand, you have active euthanasia. Think of it as a direct action, like a doctor giving a lethal injection to end a patient's suffering. In India, that is completely illegal. But on the other hand, you have passive euthanasia, and this is where things are different. This is about allowing someone to die naturally by stopping or not starting life support. Things like ventilators or dialysis. So, the big takeaway? It's not about actively ending a life, but about not artificially prolonging one. It's a huge distinction.
All right, so since passive euthanasia is allowed in India, you're probably wondering, well, how does it actually work? What's the process? Let's get into it.
So this isn't a simple decision. There's a whole multi-step process designed to make sure everything is done carefully. Step 1, it all starts with the treating physician. They have to determine that, sadly, there's just no hope of recovery. Then, step 2, it's not just one doctor's opinion. A primary board, which includes the treating doctor and 2 other experts, has to review the case and all agree. Step 3, and this is so important, is the family consultation. Doctors and the family have to talk it all through and make a shared decision. And finally, for step 4, there's another layer of protection. A second, completely independent medical board has to approve the decision, and they have to do it within 48 hours. So you see, there are a lot of safeguards built in.
And believe it or not, there's even one more step. The hospital also has to inform the local magistrate before they withdraw any treatment. Now, the magistrate doesn't have to sign off on it or give permission, but just informing them creates an official record. It's all about adding that extra layer of transparency. Okay, so we've got this official procedure, right? It sounds pretty thorough. But here's the thing. Having guidelines on paper is one thing. What happens in reality can be a whole different story. There are some major hurdles.
And this is a big one. It's a logistical nightmare, really. Devani Mehta, a legal expert from the Vitti Center for Legal Policy, puts it perfectly. She points out that it's tough to find doctors with the right experience in every hospital. But the real kicker? She says very few states have commenced the process of actually creating this list of nominated doctors for the secondary medical board. Think about that. The whole system depends on this secondary board, and in most places, the list of doctors for it doesn't even exist yet.
And take a look at this. It really shows you the scale of the problem. You can see that a huge number of states just don't have these lists ready. There are a few, like Maharashtra, Goa, and Karnataka, who've started the process, but they're the exception. For most of the country, there's this massive gap. We have a law, a right, but the actual machinery to make it happen is just not there. And for a family going through this, what good is a right on paper if you can't actually act on it?
It's not just about paperwork and logistics, though. There's a deeply human side to this, too. Dr. Sushma Bhatnagar, who's an expert in palliative care, brings up 2 really powerful points. First, hospitals are terrified of litigation. They're afraid of getting sued. And second, and this is just heartbreaking, is the guilt that families face. It's an unimaginable decision to make, and that emotional weight can be crushing. So, with all these roadblocks, the logistical gaps, the fear, the guilt, it begs the question, is there anything we can do? Is there a way for a person to make their own wishes clear way ahead of time to make things easier for everyone involved? Well, thankfully, there is. And that's where something called a living will comes in. And it is so important. So what is it? Simply put, it's a legal document. It's something you make while you're perfectly healthy and of sound mind, and it just spells out exactly what you want for your medical care if you ever get to a point where you can't speak for yourself. The whole point of a living will is to give you the power and to create clarity before there's a crisis. It lets you do some really specific things. You can choose what kind of medical care you want, or, just as importantly, what you don't want. You can also name a specific person you trust to make those decisions for you. You can even specify personal preferences, like how you'd like to be addressed. It's all about making sure your wishes, your dignity are respected.
And just think about what a huge difference this can make. For a family that's agonizing over this decision, wrestling with all that guilt, knowing they are simply following their loved one's written wishes can be a massive relief. For the doctors, it takes away all the guesswork. A living will really does transform what could be a moment of terrible uncertainty into a final act of honoring someone's choices.
Which brings us back to the central challenge, doesn't it? In India, the right to choose a dignified death is legally recognized. We have that. But between the law and the reality, there's this huge gap filled with administrative hurdles and really complex human emotions. So the big question we're left with is, how can we bridge that gap? How do we get from simply having the right to choose to actually being able to act on that choice?